Mr President, I lead for the opposition in debate on the Limitation Amendment Child Abuse Bill 2016. The opposition supports the bill before the House. That should be a surprise to no one, given the opposition introduced a similar bill last year, although of course the government, the current Attorney-General, spoke against it and voted it down by the narrow margin of 39 votes to 36 in the other place. The object of this bill is expressed to amend the Limitation Act 1969 to ensure there is to be no limitation period for an action for damages that relates to death or personal injury resulting from child abuse. The term child abuse is defined to mean abuse perpetrated against a person when the person is under 18 years of age, that is sexual abuse, serious physical abuse or other abuse perpetrated in connection with sexual abuse or serious physical abuse. We do not believe that the current exceptions to limitation periods under the Limitation Act provide a sufficient access to justice for victims of child sexual assault or abuse. We acknowledge and agree with evidence before the Royal Commission into institutional responses to child sexual abuse that indicates that many victims have faced a number of barriers to pursuing civil claims over the years, and that of those who have, many have found the process of civil litigation to be traumatic and difficult. One of the greatest hurdles to pursuing a civil claim for child sexual abuse is, of course, the application of the Limitation Act, which most practising lawyers, or those who have practised in this place and in other places, will be familiar with. We understand and agree with the significant difficulties experienced by victims of child sexual abuse in attempting to rely on the exceptions in the Limitation Act. And we note also the Royal Commission's interim report, which found that on average it takes a victim 22 years to disclose sexual abuse. We believe it's well documented. There are many reasons why victims of child sexual abuse do not report or disclose abuse for many years, if at all, including shame, an inability to recognise the abuse was a crime, and a lack of access to therapeutic services to help them emotionally prepare themselves and to seek redress. We note also submissions, including from the Women's Legal Service, supporting an exemption for all matters in the Limitation Act involving claims of sexual assault, regardless of the age of the victim at the time of assault. And we note the support of that group and other groups for an amendment that would recognise the shame and distress caused to victims of sexual assault and the consequent delays in reporting to police and ultimately the taking of any civil action. However, we note that the bill does not go that far. It deals with child sexual abuse only. And of course, one of the curious effects of the bill may be that where a person was the subject of systematic and ongoing abuse and mistreatment, both before and after their 18th birthday, this bill will lift the limitation restriction for those acts that occurred before a victim turned 18, but will keep the barrier in place for assaults or abuse post the age of 18. Now, we understand that this bill is congruent with the explicit recommendations of the interim report of the Royal Commission, but we do think there is an area where there may be further fruitful attention directed by the government that we earnestly entreat them to examine closely, because it would be a distressing and artificial situation if only partial justice was made available to people who have suffered this terrible and traumatic behaviour by those in positions of trust and authority in connection with them. Imagine a situation, if you will, where abuse goes over an extended period, whether it's 5 or 10 years. The victim finally manages to become resilient enough to seek redress, including in the courts, but only part of their claim can be entertained as a result of this bill. The bill lifts the barrier for acts pre-18, but leaves the current restrictions in the Limitation Act in place post-18. Now, I'm happy to be wrong about that reading of the bill. Nothing would make me happier than to be wrong about that analysis. But I feel that while this is a good step in the right direction, there is that problem caused where abuse covers a number of years, including post people turning 18. Returning now to the main part of what I wish to say, there are of course a number of reasons to justify limitation periods in the law. There are benefits to resolving civil proceedings as near as possible to the time of any alleged injury. It avoids what might otherwise be problems with evidence and avoids the difficulty of deciding cases well after the events concerned occurred. Limitation periods provide certainty to defendants and, of course, those insurers on risk. On the other hand, there is the reality that many survivors of institutional childhood abuse simply are unable to disclose until many years later, which I have already indicated. The Royal Commission report refers specifically to cases in this state where claims could not be pursued because of limitation periods or could be pursued only after lengthy, time-consuming and expensive litigation. The report referred to cases arising out of the Parramatta Training School for Girls, the Institute for Girls at Hay and Bethcar Children's House. The report also referred to the case of John Ellis. The Royal Commission report also cites significant stakeholder support for the recommendations it eventually made, which are included, or at least largely included in this bill. There are a number of real problems with limitation periods for the survivors of child sexual abuse. Often a large amount of time and effort is expended arguing about the limitation period and whether it should be extended. This happens in particular because victims of child sexual assault not unusually take very long periods to disclose what has occurred. That is now so widely known and so widely accepted it shouldn't need elaboration, and of course it's embodied in that interim report of the Royal Commission. It also suggests that the system of limitation periods and extensions that currently exist has developed without much regard being had to these types of circumstances. They would more typically have developed in the context of a range of other types of claims. As one survivor told the Royal Commission, the current limitations regime is designed for someone tripping over in Kmart, not for victims of child sexual abuse. As the Royal Commission report noted, limitation periods are a significant, sometimes insurmountable barrier to survivors pursuing civil litigation. As a practical matter, there does seem to be a far lesser reliance by defendants in this jurisdiction on pleading limitation periods than in the past, and the government has made some announcements about its attitude on this. However, whether limitation provisions are relied upon should not be simply decided upon by the policy of a defendant. They should be settled as a matter of principle and a matter of law. So we think establishing this principle in legislation is vitally important. When the Honourable Shadow Attorney General in the other place introduced his bill last year, he noted that the government's policy had meant that government institutions not relying on the limitation period was occurring, but that's an unsatisfactory way to proceed, and so we think this is a good thing. The genesis of this bill is the Royal Commission. Its recommendations included the following, and I quote, 85, state and territory government should introduce legislation to remove any limitation period that applies to a claim for damages brought by a person where that claim is founded on the personal injury of the person resulting from sexual abuse of the person in an institutional context when the person is or was a child. 86, state and territory governments should ensure that the limitation period is removed with retrospective effect and regardless of whether or not a claim was subject to a limitation in the past. 87, state and territory government should expressly preserve the relevant court's existing jurisdictions and power so that any jurisdictional power to stay proceedings is not affected by the removal of the limitation period. 88, state and territory government should implement these recommendations to remove limitation periods as soon as possible, even if that requires that they be implemented before our recommendations in relation to the duty of institutions and identifying a proper defendant are implemented, unquote. The Victorian government adopted these reforms expeditiously last year, and of course the same should have occurred in this state in accordance with the Royal Commission report, but it did not. However, this bill does retain the jurisdiction of the court in relation to state proceedings, and it also has a retrospective application. We note that the the Royal Commission report includes broader issues, including the issue of redress, which was touched on, I think, by the attorney in her second reading speech. And I note that both state and federal Labor parties have been on the record supporting a national redress scheme. The arguments in favour of that proposition, rather than relying on a state-by-state or jurisdiction-by-jurisdiction approach, are clear and overwhelming. And we note the federal Labor opposition has committed $33 million to fund a national redress scheme, and that position was reached in consultation with the Labor opposition in New South Wales. We note with regret the apparent reluctance of the current federal government to pursue a national scheme. The issue for the federal government will arise if there is the pursuit of a separate state-by-state scheme, which is likely to reveal differences in the quantum of amounts that can be recovered, which of course gives rise to injustice. Particularly in this difficult area where there is belated recognition and even more belated action, it would be adding insult to injury if there was to be a sort of a patchy approach to the issue of redress. So we do hope that the federal jurisdiction, whoever the government is, will sensibly and appropriately square up and address this issue on a national basis. However, that's a debate for another time and possibly another place. We think that removing the time limitations of the kind that are embodied in the bill is a matter of justice, although significantly delayed. We wholeheartedly support the bill in so far as it goes. I know there's likely to be some amendments dealing with the issue of serious injury. Can I indicate that the Labor opposition will be supporting those amendments? But we also asked the government to look closely at the issue of the way in which the bill is drafted, and in particular to what we see as that potential vice where abuse covers a number of years, including both before and after a victim turns 18, because it is our belief that this bill will only lift the limitation period in relation to the pre-18.
Give me a call back.
I acknowledge that interjection, and so although not able to deal with that issue today, it would be a good thing, and I think all reasonable people in this place would support remedying that problem that we think exists in the bill in its current form. With those comments, Mr Deputy President, the opposition will be supporting.